Our next speaker is Debra Smietanski. She's special counsel and estate planning attorney with Foley and Lardner in Tampa, Florida. She focuses her practice on complex estate planning techniques for high net worth individuals. She's board certified by the Florida Bar in wills, trusts, and estates. She's also a licensed certified public accountant and a member of the Florida Institute of Certified Public Accountants. She received her JD cum laude from the University of Illinois, earned a BS degree in accounting from the University of Illinois with highest honors. She's admitted to practice in Florida and in the state of Illinois. She's going to be talking to you about what advanced directives you can prepare to make sure that your wishes to exclude clergy at your final moments are heeded. Ms. Smietanski.
And I want to thank you for inviting me here this afternoon. I very much appreciated Lois's presentation because it tells you, as an attorney at least, it tells you the roadblocks that could be put into place after you draft the documents, which a lot of times lawyers don't totally realize that all their good drafting and planning may just be all for naught in some situations, hopefully not all. So what I'm going to do is simply to go over the legal framework for planning that would express your wishes as to how much or how little, how much religious ritual you would like to have in your final days and after your death. In the estate planning world, we do a lot of this kind of work. But just as a general matter, general considerations to be had in the situation. It's always good, whatever documents you're drafting, et cetera, to try to put this into place, that you be very specific. In other words, and it's not a bad idea to be verbose in this situation. You need to state your preference specifically with regard to religious ritual and religious personnel, so as to avoid any confusion as to what your intent is, because we'll see later on, intent is rather key to making this determination as to how these will be carried out. This is another important point which people don't realize a lot, that none of these documents that I'm going to be discussing are self-executing. You need to identify and enlist advocates to carry out your wishes. So any of these people that you appoint in positions of authority in your estate planning documents, like your personal representative, sorry. I don't put executor down here because in some states they do call them executor, but I'm talking within the framework of Florida law, so excuse me for that. Trustees, healthcare surrogates, guardians, any other types of agents. It needs to be someone that understands your desire and respects what you're trying to do here, and will respect what you have said, and that you either do or do not want religion to be part of your final days, and will be willing to advocate on your behalf. In other words, it's nice to have someone that respects, understands your wishes, but they have to have that kind of personality, I think, that's not afraid to speak up when that's necessary. And please do not delay in putting these things in place. I mean, I can tell you a lot of stories about people who delay in the estate planning context, and then something happens unexpectedly, and that's, you can't do much after the fact. And to review the choices on a periodic basis. Things change in your life. People change in your life. People who may have been involved before in your life and are not anymore, or maybe they've gone in a different direction than you and they don't really want to advocate on your behalf. So it's important to look at these things periodically. So what kind of estate planning documents do we have that are enforced prior to death that would take in consideration those things that you want to eliminate from happening if you become ill or incapacitated prior to your death? Obviously, healthcare advance directives, and I think we've heard a lot about those already today. Not going into a lot of detail here, but in a healthcare advance directive, which is what we call them in Florida, sometimes these documents, these types of documents are really authorized under every state's law. They may be just called something different. In Florida, we call them healthcare advance directives, and I have a combined one that includes the living will provisions plus the appointment of a healthcare surrogate. But the healthcare surrogate is to ensure that if you should become incapacitated and can't make these decisions on your own, because you're always in control. So if you have the capacity, you're going to make those decisions. But this person steps in when you cannot do that. That you have appointed someone to make those decisions when you're incapacitated. And so it's a good idea in this document then, and you can make this document as long or as short as you want. There's actually, in the state of Florida, kind of a shortened version in the code section itself where it's authorized. But you need, if you've got some specific preferences here with regard to religious ritual, you need to state those preferences specifically. Again, this establishes your intent, if that becomes necessary to prove in a court proceeding. And you should incorporate specific wishes with respect to the involvement of a religion. At a time then, even in nursing care, when you may be in a weakened condition, you may not be totally incapacitated, but you could be in a weakened condition, and you're rather incapable of communicating what your desires are. In a lot of instances, even if you're not totally incapacitated, whoever your surrogate is, the hospital personnel, the nursing care personnel will recognize and talk to, because you've given them the authorization to talk to these people. And they actually prefer and would like to have somebody like that around, another person to talk to that, of course, is not in that weakened condition, and they can help the situation along. We have also pre-need guardianship designations. You can name somebody that would act as your legal guardian before that may be necessary, which is a good thing to do, I think. Again, you're appointing an advocate that can help make those decisions when maybe you can't, and you want to be sure that you appoint someone that understands and respects what your belief system is. Financial durable powers of attorney. Sometimes people don't think about this so much in this respect, but I do, because that's the person who controls the purse strings. Again, if you have the capacity, you're going to be making those decisions, but if you appoint an agent to handle your financial assets and you become incapable of dealing with that, then this person's going to be spending money on things, and you got to make sure that they spend money on things that, again, are in keeping with what your preferences are under the circumstances. We use a lot of revocable living trusts in Florida. They probably use them in other states too. They can be used in the same manner as a durable power. They're a little bit more comprehensive in that you're transferring your assets to a trust, so to avoid guardianships, to avoid probate, but you appoint a successor trustee to take your place when you cannot do this any longer. And again, they're controlling your assets. They're making these decisions of how things, can be spent, or even what hospital institutions you may be going to, and maybe that you should be transferred to someplace else if that's more in keeping with your personal wishes and desires at this point in time. Then we have, of course, estate planning documents enforced at death, which in some cases are many of the same documents. The Healthcare Advance Directive, of course, deals with end-of-life decisions too, but of course when you pass away, it's gone. The durable power of attorney, of course, is gone. That dies when you die. But you can incorporate your instructions as to disposition of your body, your funeral preferences, or non-funeral preferences for that matter, in any type of separate writing, including a last will and testament, a revocable living trust, or even a signed letter to that effect. Under Florida law specifically, cremation, if that is your desire, that occurs pursuant to a written direction signed by the decedent, is a complete defense to a cause of action against any person who is relying on that direction. And I think there were a series of cases that kind of brought that to the forefront, and that's why this provision was placed in the code. So that if that is your wish, and it's followed, hopefully the person that's followed the directive cannot be sued successfully, at least. And people can always sue people, but hopefully not successfully. It's important, again, to provide all of your people who are in control of this, people in a position that you've nominated them for, like your future personal representative, your successor trustee that will take over under your revocable trust, any other individual advocate of yours, friend, and this could be, it doesn't have to be family members necessarily, maybe sometimes it's not going to be a family member depending upon their viewpoint. But you can nominate anybody you want as long as you feel comfortable with them. A copy of these documents, you have to provide a copy of these documents to them. I think it's important that they know that they're appointed and they know what's in these documents. And they also have to buy into this. They have to accept the appointment eventually, because no one can force someone to act in these positions. If they feel uncomfortable, it's good to know that before and not after the fact. So, as I said before, these written instructions are controlling under Florida law. That establishes your intent, which is what case law under Florida primarily is based upon in carrying out your wishes. Otherwise, you may be in a position that your next of kin would control these decisions, which maybe is obviously knowing your own family, you might not like that result at all. Prepaid funeral arrangements is kind of a practical way of dealing with some of this because it can be useful in that you've prepaid something and established a plan for your funeral or your whatever service that you would like, and whether you're going to be your method of burial or cremation. Beforehand, you've paid for it. And many times your heirs are very, it's not going to be the usual case in which they would want to spend additional money changing your plan if you've already paid for it. And so, because many times people are interested in getting the assets from your estate. So if you've kind of made these decisions in advance and actually set aside the money for them and paid for them, more likely that they would be carried out. And it's important that your nominated personal rep, successor trustees know about this, and you give them copies of all of this information so that it can happen, in a logical manner and actually really happen after your death. There is a kind of illustrating this point and the intent point. There's a kind of a famous case in the state of Florida involving Nicole Smith. I don't know if you ever remember her. She was that luscious model. I don't know what else she was. Playboy person who, as you recall, married a very wealthy octogenarian. And so she had been involved in a lot of litigation even before her death. When he died, she, of course, made her claim to half of his estate. And so she was involved in litigation because of that, because his children weren't that crazy about that happening. And so, but then she died unexpectedly from a drug overdose. I'm not so sure exactly. I think it was, they weren't really quite sure whether it was actually intentional or not. But she died unexpectedly, and she had a minor child. She had had an older son who had died before her and was buried in the Bahamas. But then what happened after her death, among a number of things, was the disposition of her body. And there became a big fight over that in the state of Florida between her estranged mother from Texas, who wanted to bury her remains in Texas, and her companion, who she wasn't married to, but I guess was very close to. They wanted to bury her in the Bahamas by her son. And so what she had actually done before that is she actually bought a plot by her son. And so even though she had failed, of course, to write any of this down, which is, I think, essential, an essential first step to getting your intentions carried out at death, she at least prepaid something that established her intent pursuant to the law. The appellate court eventually ruled that her burial in the Bahamas was enforceable and what she would have wanted to do because her intent had been established by the purchase of this lot and by other testimony given at trial. So she ended up, I guess, hopefully being buried where she wanted to be buried. So that's a good lesson to be learned. So I want to thank you very much for your rapt attention here, and a kind of sometimes a dry subject, but a necessary one. And I think we'll be open for discussion or questions later, right? Okay. Thank you very much.